resides at the time of the accident involving the uninsured or underinsured motor vehicle, or the county where the accident occurred, right? And this lawsuit, Your Honor, filed by Julie Forbes, she's a resident of Harris County, and the accident took place in Harris County. And therefore, based on the Texas Insurance Code, a mandatory venue provision, we're asking that venue be transferred out to Harris County, Your Honor.
Ms. Fox?
Yes, Your Honor. So the Texas insurance code that he was referencing, I believe, is only in play if there is only the insurance company as a defendant. And in this case, we have Lillian Perez, who at the time of the wreck, and I believe at the time of filing, was also a resident of Dallas County, and that is why we believe venue is proper, as well as the co-defendant in this case is opposed to transferring venue to Harris County as well. That is why we are requesting that the case stay in Dallas County, because the actual named defendant in this case is more likely and more agreeable to Dallas County in this case. And also, it's in the insurance company. I don't see there being any burden or harm to an insurance company that does a substantial amount of business in Dallas County as well to appear in Dallas County, but the named defendant, Lillian Perez, I think would be burdened by having to go to Harris County.
Okay, response?
Yes, Your Honor. There's no exception that's provided in the Texas Insurance Code to the venue provision, Your Honor. If the plaintiff wants to dismiss Colonial County Mutual Insurance Company and proceed on the third-party action against the defendant, then that takes us out of play, and venue is not the issue, right? But they're the ones that filed the lawsuit. They're the ones that drafted the petition and brought us in and had us served. So knowing all that, Your Honor, the statute is very clear. It's a mandatory venue provision. So unless they want to, non-suit us for the time being or dismiss us from the lawsuit, then we got to transfer this matter over to Harris County.
Ms. Fox, what case law are you relying on, or that indicates that there's some kind of exception?
Your Honor, I do not have any specific case law. I'm referencing mainly just the venue rules in the state of Texas, because I believe that the basic premise for that statute was to make it so that plaintiffs can't just file anywhere. And I agree that would be, venue picking. But in this case, we very clearly chose Dallas County because of the other defendant in this case. And that's our basis of the argument, is the venue provision. And I think it's AB2 because of the defendant being in.
Do you agree that this is a mandatory venue provision in the insurance code?
I agree that it's mandatory when there's only the insurance company available. I don't think it reads as that, but
go ahead and share screen that with me, Mr. Kim, so I can see the provision.
Your Honor, the share screen has been disabled.
Go ahead.
So you'll see here, which I've highlighted here, is 1952.110 of the insurance code. And the pertinent part, an action against an insurer in relation to coverage provided under the subchapter, of course, notwithstanding section 15.032 of the Civil Practice and Remedies Code, may be brought only in the county in which either A, where the policyholder resided at the time of the accident, or where the accident occurred, right? And so may be brought only is a mandatory provision, Your Honor. If there was no only in the statute, then it would be permissive, but because the legislature drafted the language this way and included the word only, that's what makes it mandatory, Your Honor.
Ms. Fox, what it does appear to be mandatory. Where are you getting this? I guess make your argument.
So, Your Honor, just as I stated earlier, it's based on the permissive venues in filing in the general state of Texas, and when there is one defendant in the county that is their place of residence, then you can file in that county. That's the whole crux of my argument. If the court disagrees that even when there is a named defendant that everybody has to be halted to where the insurance company is, then we're at your mercy, but that is our argument.
I mean, I'm happy to look at case law that supports your position. I'm sure there's been some, but based on, there was no response filed, and based on what I've been given, I don't really see I have a choice. And so I'm going to go ahead and grant the motion to transfer.
Your Honor, if I may.
Yeah.
Defendant, counsel for defendant Perez, under the Civil Practice and Remedies Code, section 15.005, multiple defendants. In a suit in which the plaintiff has established proper venue against a defendant, the court also has venue of all the defendants and all claims or actions arising out of the same transaction, occurrence, or series of transactions or occurrences. Here, the court has proper venue and jurisdiction over defendant Perez, who's a Dallas County resident.
Well, I have no question that there's permissive venue here. It's just, does the mandatory venue provision that's cited by Mr. Kim trump the permissive venue? I mean, there's got to be case law on this. It comes up all the time, and so I haven't seen any case law. I'm just going with the general rule that mandatory venue trumps permissive venue usually. But do you have anything that indicates, Mr. Smentek, that mandatory, that interpreting the insurance code provision that indicates that supports your position? I mean, I don't particularly want to transfer it. Trust me, I don't usually like transferring cases, but there was no response filed, and I don't have any case law to support an exception to the general rule, which is mandatory trumps general.
Yes, Your Honor.
I mean, do you have anything?
Not at the moment, Your Honor. I could provide you something if given some time.
I'll go ahead and grant it, but if you guys want to file a motion to reconsider that provides case law that supports your position, I'm more than happy to look at that. It's not that I don't want the case. Trust me, I'm happy to have it. It's just general mandatory usually trumps permissive, and there's no case law to the contrary. So, Tony, is everything okay? Tony? Tony?
I don't know if you can hear me or not, but I am.
You need to turn off the other one. Let me take care of this.
Judge, are you able to hear me?
Now I can.
Okay, I emailed Rhonda and told her I was hoping you were recording it because I just got knocked out.
I have been recording it. Counsel, apparently court reporters dropped off. This is on YouTube. Do y'all mind if she just uses the YouTube to do the transcript if necessary?
No objection, Your Honor.
No objection, Your Honor.
Ms. Fox?
No, Your Honor, sorry, I don't know if I spoke at the same time as someone.
Okay. All righty. So go ahead and get me an order on that, Mr. Kim.
Oh,
Make sure that it says at the beginning that this was heard on June 26th, 2023, as opposed to on this day. Email it to opposing counsel, as well as e-file it, and also email it to Rhonda, my court coordinator, and try to get that to me by the end of the day. Okay.
I will do so, Your Honor. May we
All
be
right, guys. You guys have a great rest of your day.
Thank you, Your
Thank
Honor.
you, Your
You
Honor.
too, Your Honor.
Okay. Right, Mr. Howard, I think I saw you here.
All right, I can't hear nothing, but I'm here.
Mr. Howard, are you there?
Yes, sir. I'm here, sir. I didn't hear you. How you doing?
Good.
We're still. I don't know where I'm on the docket. I just joined in a few minutes ago. I had difficulties. We're having problems understanding the procedure that we sent her 3 documents. The dismissal thing, the thing you told us to send, and we sent her a copy of the contract. The problem was you just needed us to do something, and I forgot. I just don't remember, sir. She didn't reply to us. We called her. We sent her the emails. We sent her all the documents, 3 of them. They're in her email. But I don't know what to do anymore.
All right. So according to the coordinator's notes, it says default, let me see. We needed more. So you submitted an affidavit back on February 6th. You forwarded us a default order for us to review.
Yes.
And then I told you needed a more detailed default judgment, and that you could contact Rhonda for more information.
Yeah, we sent her an email on the 16th.
Okay, did you e-file anything? Because it doesn't show up on the system. Let me share screen so you can see it.
Yes, sir.
Sorry, I didn't mean to do that. Okay, do you see that? So it shows February 6th, you submitted the affidavit. Then we ask you for more detailed information, including the military affidavit. And that's where we are. We just haven't gotten that information
Well,
from you.
in my email, my Gmail, I'm sorry, I'm in the truck. I'm in 18-wheeler right now.
Okay.
On my email, when I go to my Gmail, just one second.
Rhonda, did you get an email from Mr. Howard? Do you remember? Rhonda, are you there?
Yes, Judge, I'm back. Just let me see if I can pull that up just a
It was on the
second.
16th, Rhonda.
What day was it?
The 16th,
Okay.
Friday the 16th.
Okay.
Yeah, she emailed her 3 documents.
Well, let me try another search. Let's see it that way. Let's see if we see.
Why don't you do this?
Yes, sir.
Rhonda, why don't you give Mr. Howard a call and see if you guys can work this out? Did we get
Yeah,
this?
we're gonna call at 1 o'clock today.
I'm sorry?
We were gonna call her at 1 o'clock today to go through it with her.
Okay. Rhonda,
Is
does
that
that
good?
work for you?
Yes, that'd be fine. I just found it, Judge. I'm putting it to you now to have a look at it.
Okay. What, Rhonda, why don't you talk with him at 1 o'clock and just reset this on the DWAP for 2 more weeks?
Okay, all right, we'll do.
That's fine. We'll call you everyone. May I be
Okay.
dismissed, Your Honor?
You may. You have a good rest of your day.
You too, sir. Thanks.
Okay. Is anyone here on the scheduling conference docket?
I am, Your Honor.
Morris versus Jaimes. Anyone here in that case?
Yes, Your Honor. Kevin Jones on behalf of plaintiff Edith Venecia.
And anyone here for the defendant?
Not that I see.
Okay. So we need a trial setting on this as well as a mediator. Have you talked to opposing counsel about that?
We have desperately tried, Your Honor. We are on our 4th follow-up. We floated a lot. I offered a lot of names. They were going to mull it over, and I just haven't heard anything back in a matter of a couple months. I think the court already gave us a trial date, what I'm seeing, for October 1st of 24. I don't know if that's still available. I've proposed Phil Watkins as a mediator. That's down in my territory down here in Corpus. And then I have Lexa Ald or John Brookman up in your neck of the woods, whatever the court prefers.
All right, let me look. So August 1st is a Sunday. I'm sorry, October 1st is a Sunday. Do you mean a 23 or 24?
24.
Okay, let me see. Is that a Tuesday?
Double check.
Yep, it's a Tuesday. Rhonda, go ahead and set this for October 1st of 2024. And who are the mediators you said again?
I proposed Phil Watkins. I never heard back from them. Lexa Ald or John Brookman. I just need someone that is Zoom capable.
I don't know who John Brookman is. Who is that?
It's a gentleman over in Fort Worth. But if the court has a preference, it does not matter to me.
I know Ken Rubenstein does a lot of Zoom mediations. If you want a Zoom meet, he does a lot of that, or King Pfeiffer. I don't know Brookman. I don't know Alexa Ald. Is this a really, she tends to handle really small cases. Is this a really small case?
This one would be, Your Honor. This is just an auto.
I mean, Lexa Ald is fine too, but she does tend to handle really small cases.
I'll leave it in the court's capable hands. That way I can tell counsel that you picked them.
Well, it's y'all's choice, so.
I prefer to
I'll
use
just-
Phil Watkins if it's my choice is the only one that appeared today.
All right, what did you say?
Phil Watkins would be my option then if it's.
All right, Ronnie, go ahead and he's out of Corpus Christi.
Yes, sir.
Ronnie, go ahead and appoint Phil Watkins out of Corpus Christi as the mediator in this case. All right, anything else today?
That'll be it, Your Honor. So we just need to fill out a proposed DCO, which we have done, send it in the court for signature.
That's right.
Understood. Thank you all for your time.
You have a great rest of your day.
May I be dismissed?
You may.
Thanks, sir.
Anyone else here on the dismissal docket? Sorry, anyone else here on the scheduling? Let's see, let me look at this real quick. For the scheduling conference docket. Jones versus Lopez. Sorry, that was Jones versus Lopez. Madam Morris versus Jaimes. Or Jones versus Lopez. Anyone else here on that case? All right, they submitted agreed scheduling order on the Jones versus Lopez case.
Okay.
I want to go ahead and print that out and put it in my stack.
Okay.
All right, anyone here on Peachtree Settlement Funding versus name redacted?
I'm here, Your Honor, and the other party is Miss Sheena Price, and I see her in here as well.
Okay,
Good morning.
good morning.
Good morning.
All right. So what I see online doesn't have any information on it. So I don't. So let's deal with the first issue, which is we have a standing order for transfer of annuity payments. Have you guys already complied with the standing order?
We did. I will admit it was filed a bit late. You probably haven't had time to review it, but it was filed.
Okay, it's supposed to be filed 5 days before the hearing.
Right. I did not get it back in that amount of time.
And it's not complete anyway. How many of these have you sold? How many court orders have there been on this? Is this out of my court or a different court?
As in the original.
Yeah.
Let me see. Looks like it was originally settled.
I don't think there's any.
Let's see. No, Judge, it was out of originally it was settled out of the 116th.
All right, this should go back to the 116th. It shouldn't be in my court.
Okay. Do you want us to submit a order, or do you have one?
You would need to submit an order to Judge Judge Parker. And,
submit it directly there.
Yeah, and it'll need to be transferred. Ronnie, go ahead and put this on a 30-day DWAP, and you guys need to get that transferred to Judge Parker.
Thank you.
All right,
Okay,
thank you,
how do
Brad.
I'm sorry, just real quick. Is it, you guys helped us last time get one signed? Is it possible that, I feel like sometimes I submit these and they go nowhere.
I mean, Judge Parker is a very capable judge. I'm not sure kind of what
Okay.
you're talking about.
Okay, so just submit it over to the court coordinator there and explain what happened.
Yeah,
Okay, just checking. Thank you, Your Honor.
thank you. You have a great rest of your day.
Okay. Bye-bye. Bye-bye.
Rhonda, put this on a 30-day DWAP.
Will-
All right, Deshara versus Sparks, are both sides here on that?
Yes, Your Honor.
Yes. We're playing.
All right, let's go on the record on DC 235353, Deshara versus Sparks. Counsel, make your appearances.
Alec
Bill
Pedigo.
Masterson. Bill Masterson for the plaintiff.
Alec Pedigo on behalf of defendant Mark Sparks.
All right, let's proceed.
Your Honor, we're here today on a 91A motion to dismiss one of plaintiff's causes of action being the breach of contract. Notably, this motion is laser focused on one of their causes of action, so it will not dismiss their entire case. And to give a summary of what their breach of contract is, this is a lawsuit by a disgruntled ex-employee who's suing my client for net profits in a sale that never occurred and has not been alleged to have occurred. And even if such sale did occur, plaintiff wouldn't be entitled to exercise his rights in the contract anyway, for other conditions precedent not being satisfied. So let me, before I go any further, share my screen.
Right. I've read both sides, just so you know, but go ahead.
Can you see that, Your Honor?
Right. Yes.
Okay, so this is 91A, and we're here on baseless in law. And as the statute says, the cause of action has no basis in law if the allegations taken as true, together with inferences reasonably drawn from them, do not entitle claimants to the relief sought. Importantly, for the judge and for opposing counsel, the court may not hear any evidence outside of the pleadings. The motion must be decided on the pleadings, which include exhibits, and in this case, it's the contracts. So a little background. My client owns or controls multiple entities throughout the state of Texas that do business nationwide. Two of those entities, Everest Rehabilitation Hospitals, LLC, and Hall Fox, LLC, both Texas LLCs, are the subject of the contracts at issue before the court today. Plaintiff was an employee of 3 companies of my client that weren't Everest Rehabilitation Hospitals or Hall Fox for 8 years. He was terminated in January of 2023. During his employment with the 3 unrelated entities, my client individually and plaintiff entered into 2 contracts in 2016. Let's start with the Hall Fox contract. I'm going to share my screen again. This is plaintiff's pleading exhibit A. This is one of the contracts at issue. It's an email contract, but it's signed by the parties. It says grant of a percentage of membership interest of Hall Fox LLC from Mark Sparks' personally owned membership interest. Dear Eric, I'm pleased to hereby grant you 1.5% of my individually owned Hall Fox LLC membership interest for an option purchase price of 10. Under the following conditions, enumerated 4, in sum, he's got to be employed full-time by one of Sparks' controlled companies. He can't have been terminated, and there are no lawsuits pending against my client for any reason whatsoever. The grant, these are the important parts. This grant of Mark Sparks' personal membership percentage interest in Hall Fox LLC may only be exercised upon a controlling membership interest liquidity event, a sale of the majority or all of the company, and that none of the above conditions are violated. As an example, then it goes to give an example. It says, and should you be granted 1%, and then the contract even describes the purpose of the grant. The purpose of the grant is that you benefit from the sale of the company when or if that event takes place, should the conditions be satisfactorily met. Okay. So now let's see what he says about the Hall Fox contract in the pleadings. And remember, we're only looking to the pleadings in this motion. It's in 4.8. So he goes to say, in the contract, talking about the Hall Fox contract, defendant agreed that upon a sale of his personal 75% of defendant's stock equity interest in the Hall Fox LLC portfolio company, defendant would pay plaintiff 1.5% of defendant's stock equity interest of the net sales proceeds of the company. He generally describes the contract right in what it grants, what the condition is that triggers his right to exercise any interest. He leaves out the other conditions precedent, which is a problem in their pleadings, but that general description we agree with for the most part. In fact, in his request for relief, what he's requesting for breach of contract is net profits realized by defendant upon the sale of real estate and stock investments described in exhibits A and B here too. Okay. What's the only allegation in his pleadings that he says he's entitled to anything under the Hall-Fox contract? It can be found in section 4.8, second to last sentence. Defendant subsequently sold the assets of the company, the technological intellectual property of Hall-Fox, by selling Blue Ox Logistics LLC, into which intellectual property assets had been placed. That is his basis for the relief that he requests, in that my client breached the contract and owes him net profits. Well, as you saw in the contract, nowhere does the contract say assets. And the TBOC is clear that a membership interest is personal property, and not, and the members, who the assignee of a membership interest, or if you're a member in an LLC, you do not have an interest in the specific property of the company. So his allegations are, one, not supported by the contract itself, and two, the TBOC dispels of his argument. And let's look at the TBOC just while we're on here. TBOC section 101.016, nature of membership interest, right? Which is what was being granted conditionally, unvested, right, in the contracts that we just read. A membership interest in a limited liability company is personal property. A member of a limited liability company or an assignee of a membership interest in a limited liability company does not have an interest in any specific property of the company. So what plaintiff has pled is his allegation for breach of contract, and the relief requested doesn't get him there in the Hall-Fox. Now, I want the court to know that plaintiff had over a month to amend his pleadings to make any such allegation that would support his request for relief, meaning all or a majority of the Hall-Fox company or Sparks membership interest in the company sold. Plaintiff failed to do so, and I applaud plaintiff for not amending his pleadings and making such an allegation, because it's untrue. Sparks still owns the exact same membership interest in Hall-Fox today as he did in 2016 when the contract was entered, which is 75%. I know the court can't consider evidence in this hearing, so that's more for context, but the important part is plaintiff fails to allege any basis for relief that any membership interest is sold. Similarly,
I get it. Mr. Madison, what's your response?
Your Honor, looking at this contract, the Hall-Fox contract, both contracts are substantially the same. The contract does not provide that my client would participate in the sale of the interest. There's no provision in this contract that provides for a liquidity event being the sale of this interest. Obviously,
Mr. Pedigo, can you share the contract again? The contract.
yeah, I'm getting there, Judge. Sorry, right here. This is a Hall-Fox contract.
It says that I hereby grant you 1.5% interest in my individually owned Hall-Fox membership interest. I mean, it says the membership interest for an option purchase price.
Yes, but Your Honor, look at how they define liquidity event. It's in this paragraph that starts the grant of Mark Sparks personal membership percentage interest in Hall-Fox may only be exercised upon controlling membership interest liquidity event. Now, here's the definition that appears 4 times in this agreement. Sale of the majority of all of the company There is no provision in this contract for sharing in the sale of the interest. What the liquidity event is sale of the majority or all of the company. And if you sell the assets of the company, you obviously are selling the company. And then this goes on to say in the next paragraph that as an example, that he owns 75% total membership interest. But if you look at the last sentence, if Hall Fox were sold for a net proceeds of $10 million, and that language, if Hall Fox LLC were sold, it doesn't say if he sells his interest, his membership interest. It says if the company was sold. And then can we go on to can you roll this up to look at the last final paragraph of all right, here we go. The purpose of this grant is that you benefit from the sale of the company, not the sale of his interest. That's what they're contending, that this contract provides only for benefits when he sells his interest. But right here, it says the purpose of the grant is that you benefit from the sale of the company when or if that event takes place. And then he goes on to say, this grant does not obligate you for any liabilities, taxable consequences of a company. And then again, it says, until the company is sold. So 4 places in this agreement, it says that he benefits from the sale of the company. And that's what happened. And that's what we pleaded, that the Hall Fox company sold its software development. And that was the asset of the company as we understand it. And that was sold. So the contract in 4 different places says when the company is sold, you're going to benefit. And that would mean that he would share that this 1.5% of the 75% in the proceeds of that sale. If you look at it as a sale of the company, that when you sell its assets, then those proceeds would be distributed to.
So I get it. So that raises an interesting point, Mr. Masterson. So let's assume that you're correct, that this is really a sale of the company as opposed to sale of the interest in the company. Is there anything in the Business and Commerce Code or Business Organization Code or anywhere that defines what the sale of a company is? Is it the sale same as the sale of the assets of the company, or is that a different thing? Has anyone looked at that, or case law that defines what a sale of the company means?
I didn't specifically look at that, Your Honor, but I think if you sell all the assets of the company, I think you sold the company. That's certainly the interpretation that we give it.
Mr. Pedigo?
May I respond?
Yeah.
So this agreement is clearly geared towards the personal membership interest of a company. Now, away from the agreement, I agree with Mr. Masterson that a company can be sold, right, through a sale of the company, in this case, an LLC, membership interest. A buyer can buy membership interest of the company and basically step into the shoes of the previous owners of the company. Companies are also sold through asset purchase agreements. I'm sure you deal with a lot of those in your court. And in that event, there's a wind up of an LLC if they sell substantially all or all of their assets. And normally the company agreement and the TBOC even has provisions that relate to this, will require the wind down and termination of the company. And then you have to do a capital contribution calculation, and you make the final distribution to the members or anyone who has a membership interest in the company. But we're not dealing with either scenario here. the company, Hall Fox LLC, has not sold, in part, the one allegation, an IP transfer, which, albeit untrue, never happened, is just an alleged transfer of one of the assets. Hall Fox still has assets and is still operating today. The company is operating. It has not been sold through a personal membership interest sale or an asset sale that requires a wind up in termination.
Mr. Masterson, where do you get this argument? I'm not disagreeing with you, I just don't know. Where do you get this argument or this evidence that there was an asset purchase agreement?
Well, we pleaded it and we have evidence to it. But at this point, the company, neither Mr. Sparks nor the company is giving us any information whatsoever. So what we do know, we do have evidence, and we did plead that they sold and transferred their principal asset, and of course this agreement refers to a sale of the majority or all of the company. So it's not all of the company. You would not. This agreement is sprung by a sale of a majority, and of course, Mr. Sparks owns 75% of the company. But the whole purpose of the grant, for which my client worked for this guy for 7 years, this was supposed to be the carrot at the end of the time, is that you benefit from the sale of the company. So how does he benefit from the sale of the company unless he benefits when they sell the assets? There's no other way to benefit from the sale, from the sale.
I understand, Mr. Pettigo, your argument that this may not be true. I don't know if it is or not, or what. It says a majority of the company. I don't know if that's a majority of the assets or how that would work out. And so I think this is something that probably needs to be fleshed out in discovery. What exactly was sold, and was it a majority of the assets, or how that all plays out? But I do think, obviously, he did not get counsel to write this agreement. It's not the model of clarity, to say the least. And so at this point, I'm going to deny the motion to dismiss.
Respect what you just said, but we haven't even looked at the Everest contract yet, which has a little bit different language.
Okay, then let's look at that. I'm sorry.
Hold on. Let me at least get through that. And I want to point out on the Hall Fox and Everest, take their allegation. One, they didn't plead that majority or all the assets were sold. They said we transferred one asset. Right. So that's not in their pleadings. Oh, they sold a majority all, which requires a wind down, and therefore that's covered under the agreement. That's one. And two, we haven't even addressed these other conditions. Am I still sharing screen right now?
Yeah, you can share the screen for Everest.
All of these conditions precedent right here, these four, they have to be satisfied at the time of a sale of the personal membership interest, or, as Mr. Masterson alleged, a sale of the assets. They're not. He's been terminated. He's not employed full time.
But when did the sale occur? It wouldn't be.
Well, it didn't occur, but why don't ask opposing counsel when the alleged sale occurred.
I agree. If there's a sale that occurred after he was terminated, he would not be able to recover. If there was a sale that occurred before he was terminated, at least arguably there would be a fact issue, or at least something to go forward on if it occurred before the date he was terminated and the date he filed this lawsuit.
Well, Judge, these four conditions are all in the present tense, and you are employed full time. That was true. You are not terminated or resigned. That's true. All of those conditions are in the present tense, and there's no language in this agreement as contended by Mr. Sparks, that these conditions are to be true at the time that the sale occurs. That language is not in here. If it said that you are employed full-time now and at the time of any sale, then yes, that's the way you'd read it. But otherwise, it's all just in the present tense. And it was all of these conditions were met and satisfied at the time of this agreement. So that's really.
Mr. Master, I think maybe I wasn't clear in what I was saying. When did this sale allegedly occur?
Oh, the sale of the, now we're talking about the Everest
The
situation.
Hall Fox, I guess.
Well, the sale occurred before before he was terminated.
Okay.
Okay.
Well, let's look. You said there's a difference. How this is Hall Fox. Let's look at Everest.
Let's look at Everest. Yes, Your Honor. I'm still sharing. All right. We're on Everest. Grant of a percentage of membership interest in Everest Rehabilitation Hospitals LLC from Mark Sparks, personally owned membership interest. Same conditions precedent that we just talked about, 1 through 4. Now, this is where it gets a little bit different, Your Honor. This grant of Mark Sparks' personal membership interest in Everest may only be exercised upon Mark Sparks' personal membership interest liquidity event, sale of all the and this is the error that he points out. It's just typographical. They just didn't take out the, but it still makes sense. Sale of all of his interest in the company. And this one does say his interest. That's personal membership interest, and it's all of it. And at the time he entered into this agreement, he owned 52.5%. Today, he owns 52.5%. They don't allege that he sold all of his interest in the company in Everest. And then
Can you go to the next page?
Yeah. The purpose of this grant is that you benefit from the sale of the company when or if the liquidity event, as previously defined, takes place should the conditions be satisfactorily met. Applying the other conditions at the time of a sale, right? So it's to address Mr. Masterson's argument that they're only in the present tense when they executed the agreement. He ignores complete provisions of this agreement, especially the purpose that applies the conditions to a future sale if or when that may occur. But
right.
It refers to the liquidity.
I get it. Mr. Masterson, what's your response? Because this does seem to be a different language.
Well, it says sale of all of his interest. His interest is 52.5% in the company.
All right, so I get it. So I'm going to deny the motion to dismiss on Hall Fox. I'm going to grant it on Everest, given the different language of the agreement. Mr. Pedigo, if you can go ahead and provide, I'm not going to award attorney's fees to either side. Mr. Pedigo, if you can go ahead and get me an order on that. Make sure it says at the beginning that this was heard on June 26, 2023. Share a copy of that with Mr. Masterson. I need that order no later than this Thursday. Go ahead and email it to Rhonda as well as e-file it, okay?
Yes, Your Honor. I appreciate it. And
that's it. You guys have a great rest of your day.
Thank you, Your Honor.
Thank you.
Okay, next hearing.
Judge, was that order denied or granted?
Grant in part, deny in part.
Okay.
Spencer is everyone here on, it's not time yet, so are both sides here on Spencer v. Bushering? It doesn't look like we are.
Good, I'm here for Miss Spencer, the plaintiff.
Yeah, it's not time yet, so,
Okay, sure.
So we'll just wait.
All right. You always have busy dockets on Monday?
Yeah, that's kind of how it is.
Yes.
This has been a good one. Do this real quick. All right, I'm going to go ahead and mute for a second. Okay, guys, are you ready?
We are.
Yes.
All right, let's go on the record on, Tony, you ready?
Yes, Judge.
DC 2215199 Spencer versus Basharian. Counsel, make your appearances.
Sure, it's Jeff Clark for the plaintiff Spencer.
Jordan Shaw for the defendant.
All right, let's proceed.
On March 16th, 2023, the defendant took Miss Spencer's, the plaintiff's deposition, so March 16th. At that time, the case was set for trial on June the 6th, expedited case. So discovery closed on May the 5th of 2023. At the March deposition, Ms. Spencer testified that at the time of the accident, she had a doctor's appointment with her family doctor. She testified that she made a crash report after the accident happened. Those facts were disclosed in her deposition on March 16th. The defendant waited until May the 4th, a day before the discovery period closed, to send written deposition questions to get the medical records of that doctor for that date's visit, and for the police report, any additional information on top of the report that was produced previously by the plaintiff in this case. So what we're saying is that when they sent the written deposition questions out on May the 4th, with a response date of May 24th, 20 days from the date they're sent out, discovery period was already closed. And it wasn't like it was any new information that they just got the day before, the week before. They took her deposition 6-7 weeks before in March of 2023. So we filed a motion to quash on May the 9th, right after the written deposition questions were served. No response has been filed to our motion to quash. We think our motion to quash is good because the discovery period was already closed at the time that these written deposition questions responses would be due. So we just ask the court to follow the fact that the expedited rules on expedited cases, that the discovery period means something, and discovery period was already closed at the time these responses would be due.
Response?
Yes, Your Honor. Counsel mentions that we took the deposition of plaintiff March 16, 2023 and found out this information. As that is true, the reason we are asking for these DWQs is because on April 18th, 2023, when we took the deposition of the witness Tanya Brock, there was some other corroborating evidence. So that is why we are now at this point requesting these DWQs. We filed this before the discovery period. Before the discovery period ended. There's some red tape on our end regarding fees and such, which I won't go into, that that delays us a little bit. We can't just pay anything out, but we didn't deem the information relevant for discovery until after April 18th, 2023. So we did not do this for delay in any means, as plaintiff is insinuating. That was just how it came down, and we rushed to get it done before the discovery period ended.
The discovery period says the discovery has to be completed by the time the discovery period ends. So they're acknowledging that the discovery period closed before the responses to requests for these deposition questions were due. So it's just late. And again, they had the information in March, not in April, but in March.
I'll just say this: what my general approach to this kind of stuff is, I'm not super strict on deadlines of this type, and it usually benefits plaintiffs this time. It's kind of benefiting defendants. I'm going to deny the motion to quash as to these two deposition written questions. I'm not going to allow any other future depositions or written questions by the defendant. So Ms. Shaw, go ahead and prepare a proposed order on this. If you don't get them in before the trial setting, you're kind of out of luck, because it's a 22 case. We probably won't reach it. Well, it's an expedited case. Make sure, Mr. Clark, this is filed as an expedited case.
Yes.
Rhonda, are you there? Rhonda, are you there?
Yes, Judge, I'm here.
These are so rare. Go ahead and put this and the notes that'll print out with the case, because what I'm concerned about is we need to call this for trial because it's an expedited case on July 18th. I don't want to forget to do that. So I want it in the notes that'll print out with the case docket sheet. Does that make sense?
Yes.
So just put in big bold letters, expedited action, expedited action, because these are just not very common. And so we need to call it down the next time.
I'll be ready.
All right. Thank you, guys. Get me an order, Ms. Shaw. Make sure the order says that this was heard on June 26, 2023. Make sure you share the order with Mr. Clark and get this filed by this Thursday, no later than this Thursday.
Thank you, Your Honor.
Thank you so much, Your Honor.
All right. You have a great rest of your day.
Yeah, you too.
Let's see. It looks like we have one more hearing this morning. Let me just see. I haven't seen that this is canceled or anything. We've had a couple cancellations.
You feel you miss your interns?
We have one right. Oh, Bianca, I guess, left. Yeah, we have a couple weeks with no interns, and then we have a group of about I don't remember how many, 8 or 9 that'll be there for 3 weeks. And so this is one of the few weeks I don't have. I guess Bianca's here very part-time, but this is one of the next 2 weeks are 2 of the few weeks. And then I have a couple interns for the fall, one who's going to be coming in every week, and another one is just going to be here for 6 weeks. So we'll have some, but the having 12 at once was great, but a lot of work. So it was fun.
You're on YouTube.
I know.
Oh.
We
So
have
you
a
gotta-
hearing.
But it's a lot to keep everybody going, huh? You gotta have something for everybody to do.
Yeah, they were a great group. I really like this group of interns. They were easy to get along with and enthusiastic and hardworking and bright. And anyway, it's a fantastic group. I was really enjoyed working with them. And I think the second half, it's only 3 weeks, but I think the second half group's going to be a lot of fun too. That should be Alexis, who you met, my son's best friend. He's coming back for the second half.
Oh, good. Okay.
They told me they got you a t-shirt, Judge. Did y'all enjoy that?
Yeah, I got it. They got me a t-shirt, and they each got themselves t-shirts. It was the Hofturn class of 2023. It was really cool. It was Friday was a really neat day. They did a really nice job of kind of farewell. So it was fun.
It'll be a good reunion. Everybody's gonna wear their t-shirts.
Yeah. Well, do we know if this other case is still going? I'm a little surprised no one signed on.
And I don't think I've received anything on it yet.
Let's see.
And
Oh, here they are. I know there's Bianca. Hey, Bianca. Bianca, are you there?
I just wanted to log on really quick to tell you that I'm not going to be able to come tomorrow, unfortunately. So yeah, I just found out. So
Okay.
Thank you.
I knew that was kind of you weren't sure. So
Yeah.
Were you going to come in on Friday, or do you know if you can do that?
Yeah, Friday for sure. Yeah.
Okay. No
Okay, thank
worries. Well, are you going to stay on for this, or are you going to?
Yeah. Until what time do I need to be here, or like at what time can I log off, or?
we have a hearing at 11, I think, and then we
11?
signed on. So then we'll have
Okay.
a break until 1:30.
Okay. Yeah, no, I can stay on.
Okay. If they're going to sign on, I guess we don't know right now.
Okay.
Rhonda, can you call the plaintiff's attorney and just find out if they're, Thomas J. Henry, but can you find out if they're going to be signing on or not?
Okay.
Or the defense attorney?